Hello, and welcome to the Department of Mental Health training regarding DMH exceptions. Today, you will hear information about who is disqualified from employment, who is eligible for an employment exception, requests for exception to waiver rules and regulations, and exceptions to administrative rules. Please note, the following presentation does not purport to establish legal standards that are not contained in statutes, regulations, or other competent law. Statements contained in this presentation that are not embodied in the law are not binding on DMH. Summaries of statutory and regulatory provisions in this presentation do not purport to state the full extent of the statutory and regulatory requirements of the cited statutes and regulations. This presentation is for educational purposes only. The Exceptions Committee is established under Sections 630.556 and 630.170 of the Revised Statutes of Missouri. This process allows individuals who would otherwise be exempt from working in facilities funded or licensed by the department to pursue obtaining employment in such a facility. The committee also approves exceptions under other administrative rules. The Exceptions Committee meets via WebEx twice a month on the first and third Mondays, with the exception of holidays. Exception requests are not entertained outside of these meeting times. Completed request packets must be received 1 week prior to a meeting to ensure placement on the agenda. Requests received after this time will be placed on the next meeting's agenda. There are 3 categories of requests: an exception under 9 CSR 10-5.190 that includes criminal history, an exception under 9 CSR 10-5.200 regarding EDR placement, that is for anyone who's been placed on the DMH Employee Disqualification Registry due to abuse, neglect, or misuse of consumer funds and some disqualifying crimes, and a waiver of a DMH rule or regulation. The Exceptions Committee also reviews requests to waive rules or regulations pertaining to fire codes and standards. We will not discuss exceptions for fire codes today, but if you want information on exceptions for fire codes, you may visit our website and contact the Exceptions Committee coordinator. Under Missouri Revised Statute 630, within 2 working days of hire and prior to client contact, the agency should request a criminal background check by making an inquiry to the Department of Social Services and Department of Health and Senior Services to determine if the person is on the employee disqualification list. The agency must also make an inquiry to the Department of Mental Health to determine if the person is on the employee disqualification registry. Within 2 working days of hire, the agency should also request a criminal background check from the Missouri State Highway Patrol. This can usually be done through the Family Care Safety Registry, which will include findings from all of the departments discussed here. So who is disqualified? Anyone having been convicted of or pled guilty to any felony offense referenced under Missouri Revised Statute 630.170.2. As noted on the slide, there are certain crimes which are excluded from the exception process. In other words, a person guilty of one of these offenses cannot request an exemption and therefore cannot work in a facility funded, operated, or licensed by DMH under any circumstance. Generally, the crimes included in this list are felonies involving drug crimes, offenses against the person, sexual offenses, offenses against the family, robbery, arson, burglary, and related offenses, stealing and related offenses. These are all felony offenses. Misdemeanors are not disqualifying, with the exception of failure to report abuse and supplying unfit food. Felony DWI convictions under Senate Bill 229 states if it is a DWI misdemeanor or it's a felony persistent, this is not disqualifying. It has to be aggravated or chronic. These are the 2 key words to look for on the Family Care Safety Registry.
Misdemeanors and local ordinances. Only 2 misdemeanors are disqualifying: abuse or neglect of residents, failure to report, section 198.070.3, furnishing unfit food, section 630.160. Only these misdemeanors are disqualifying. Other misdemeanors and local ordinance offenses are not disqualifying. As the employer, you may still decide not to employ someone with a local ordinance or misdemeanor drug charge or any other misdemeanor conviction if you have concerns with the charge or conviction. Individuals can request an exception from a conviction after 12 months. Pursuant to 9 CSR 10-5.210(1), a person may not request an exception until 12 months have passed since the sentence of the court or since the department gave official notice of the person's name being added to the Department of Mental Health disqualification registry. An individual who is charged with a crime is not legally guilty of that crime unless and until they enter a guilty plea or are found guilty by a jury or the court. Guilt is the disqualifier. Again, if you are concerned with the pending charges, you do not have to employ this individual. What if my employee is charged with a felony? A person is not disqualified under Section 630.170 until such a time as the individual is convicted or pleads guilty to a disqualifying offense. It is up to the employer's discretion, taking into consideration the charged offense and the nature of the services provided, to decide how to handle the individual's continued employment. If the person is currently working under an exception, the committee may choose to rescind an exception for new charges filed. If you wish to continue to employ them, they can continue to work until they plead guilty to a disqualifying offense. Once they plead guilty, they are disqualified as of the date they plead. The committee only considers convictions, not charges. If someone has pled guilty to a disqualifying felony and receive a suspended imposition of sentence, SIS, or suspended execution of sentence, SES, they need to request an exception, even if their attorney told them it would fall off the record. Employers need to ask potential employees if the applicant has ever pleaded guilty to a crime, including an SIS or SES. Missouri Revised Statute 630.170 addresses the inclusion of the SIS and SES convictions. The person must wait 12 months after the plea or finding of guilt to request an exception. What if my employee was originally charged with a felony, but it's pled down to a misdemeanor? This would not be a disqualifier to work with the department. However, the employer must decide if charges alone violate any company policies and if employment should be terminated regardless of the result. Another popular question is about the good cause waiver. If I have a good cause waiver, do I still need to request an exception? If an individual obtained a good cause waiver to work at a long-term care facility that is licensed under Health and Senior Services under Chapter 198 of the Missouri Revised Statute, and if they're still seeking employment at a long-term care facility, they do not need an exception from DMH. But if they move from a long-term care facility to a DMH provider, then they will need the DMH exception along with their good cause waiver. To restate this, if someone's on the employee disqualification list, EDL, with the Department of Health and Senior Services, they first need to obtain a good cause waiver from the Department of Health and Senior Services before they can request an exception to work for DMH. We'll now discuss decision letter contents. The committee will notify the requester within 45 calendar days via email, fax, or regular mail of the decision. The letter will contain basic information, including approved, denied, or limited employment. There is no additional explanation. Sometimes the committee will request additional information about you or your desired employment. You will be notified if this occurs. Committee decisions are not appealable. However, the applicant can reapply once every 6 months. Once the exception has been approved, it's effective the date of the meeting. The committee coordinator will get the notifications out as soon as possible, as it's understood it is necessary to start employment. However, the committee coordinator does have 45 calendar days to send the notifications. Denial notifications also go out as quickly as possible, not to exceed 45 days. If there is a facility noted in the packet, the committee coordinator will email the facility if email information is provided. However, the facility should follow up with the coordinator for the committee decision. Types of employment exceptions. Open. The individual may work anywhere within DMH's authority in any capacity. Limited. The individual has permission to work subject to certain limitations. Examples include place of employment, role or type of work, behavioral health only, no developmental disabilities, specific consumer.
Sometimes the committee will limit their exception when they review a case and the committee is uncomfortable approving an open exception. If the employee wants to move to another facility, they would have to submit another request through the committee. This allows for more oversight. When changing employment, the requester does not have to redo the whole packet. They will submit a new letter to the committee explaining what their job title would be, what their duties would be, where they want to work, and if they have had any positive lifestyle changes since the last letter limiting them. They also will need to submit a current background check from the Missouri State Highway Patrol, if it has been longer than 6 months, along with updated probation status. There is a possibility they could be granted an open exception if they are off probation and it looks like they're doing well. Several years ago, the department had some requesters create their own version of an approval letter. The provider agency needs to be sure and review the decision letters closely, and if there is any questions about the validity of a letter, feel free to email the letter to the committee coordinator, and they will be happy to verify if the letter is valid. Some things that you need to be looking for: make sure that the letter is from the Department of Mental Health. Check for typographical errors and misspelled words. The contact phone number should reflect the Exceptions Committee coordinator, and that number is 573-751-8202. What if my employee incurs a new charge after being granted an exception? The department has a rescission process for these types of situations. The committee may rescind an exception if the applicant receives a new criminal charge. Please note, this does not have to be a new conviction. A new charge, even without a finding or plea of guilt, could result in rescission. If, for example, they receive a misdemeanor stealing under a local ordinance, this can give the committee grounds to rescind. The committee can also rescind if the provider failed to meet a condition of the exception, the request contained misleading, incomplete, or false information from the applicant, or the exception results in poor quality of care. The department receives a number of questions about the Child Abuse and Neglect Registry. Findings alone on this registry are not disqualifiers, and an exception is not required. However, if the provider agency is uncomfortable with the results of this child abuse and neglect result, they ultimately will have the right to decide to deny employment. The department only goes by criminal determinations of guilt. This is what a DHSS letter looks like, and this notification usually comes from DHSS and looks like this. The heading will reflect Missouri Department of Health and Senior Services, and on the top right, it states Child Abuse Neglect under the FCSR caption. You will see this is showing that it is regarding the Child Abuse and Neglect Registry. This page is what a finding would look like. This is what the findings look like. At the top, you're going to see that it is from DHSS and regarding the abuse and neglect findings. Toward the bottom, you see the date of offense, the category, and the severity. Unless the individual has pled guilty in a court of law, they are eligible for employment if the employer feels like they want to hire them. However, if the employer is concerned with findings on the Child Abuse Neglect Registry, they do not have to offer employment to that individual. The exception and EDR removals per Regulation 9 CSR 10-5.200. Missouri Revised Statute 630 prohibits people working in mental health programs who have been placed on the DMH Employment Disqualification Registry due to abuse, neglect, or misuse of a consumer's money or property. In some situations, a person can ask for an exception to this employment disqualification or EDR removal. Here we will review the information related to this and the process. Under 9 CSR 10-5.210, a person may not request an exception or to be removed from the EDR until 12 months have passed since the department gave official notice of the person's name being added to the registry. When the employer finds their prospective employee has a disqualifying conviction, the individual is not eligible for employment until the exception has been obtained or the request to be removed from the EDR has been granted.
Under 9 CSR 10-5, subsection 210, a person may not request an exception or to be removed from the EDR until 12 months have passed since the department gave official notice of the person's name being added to the registry. When the employer finds their prospective employee has a disqualifying conviction, the individual is not eligible for employment until the exception has been obtained or the request to be removed from the EDR has been granted. Individuals who have been placed on the EDR before August 28, 2012, have the option to request removal from the EDR, as all placements before this time were permanent placements. Individuals placed on the EDR after August 28, 2012, are placed on the EDR for a set amount of time, 2, 5, or 10 years, or permanently. However, these individuals can request an exception from the committee once a year has passed since their placement on the EDR. Sometimes an eligible individual will request EDR removal, but the committee still wants to monitor them. The committee can approve an exception instead. In this case, the individual is still going to have a finding on the EDR because the exception does not take them off the EDR. This gives the employee a chance to prove themselves. The individual can reapply once every 6 months and request to be removed from the EDR. The committee also reviews requests for waivers to DMH rules and regulations, in addition to fire code regulations through the National Fire Protection Association. One waiver is to employ a person without the specific education or required experience. The committee may consider a request from employers that want to hire a specific person to be employed in certain positions. Perhaps they have an employee under 9 CSR 30-4, subsection 34, with the social work background who is currently a social work student, having completed most of their credit hours. With the exception, they go ahead and employ them as a social worker if they are close to graduation. In order to request a waiver to an administrative rule, the committee has a short instruction sheet. The requester will submit the request in writing and will cite the specific rule needing to be waived. You should include the reason, how it would benefit the agency or client served, and any actions you propose to do in place of the requirement that you feel satisfy the intent of the original regulation or rules. In addition, any individual requesting a waiver should submit any transcripts, certifications, etc., which they have obtained and which they feel would support their request for the specific waiver they are seeking. You need to have at least one relevant professional reference in any expert consultation, which you believe supports your request. If you talk to any of the DMH employees about your waiver, you should include those names as well. We have available on our website the list of disqualifying crimes, both of those eligible for an exception and those that are not, as well as resources for requesting an exception or removal from the EDR. Go to dmh.mo.gov and at the very bottom of the page, under For Your Information, you will find Employee Disqualification Information. And if you still have questions after reviewing the website, you can contact the Exceptions Committee Coordinator at area code 573-751-8202 or send an email to exceptions@dmh.mo.gov. And thank you.